各位同事，非常繁忙一日，咁就
Members, we have a very busy day. This is the Bills Committee on Employment Amendment Bill 2014. This is the fourth meeting. We have a quorum. Let's invite the administration to join us.
好，歡迎政府各位。
Welcome. We have representatives from the Labour Department and the Department of Justice. I'm not going to introduce them. The last time, on the 10th of May and the 12th of May, members have asked some questions. There is a written response from the administration, paper number CB bracket 21588, 13 to 14 bracket 01. Mr. Hui, could you please take us through the response paper? The response paper covers a number of areas. First, payment in lieu of statutory paternity leave, PL. Under the current legislation or proposal, advance notice has to be given to the employer for entitlement to statutory PL, and the employee is required to furnish documentary proof for entitlement of PL pay. And members expressed a concern that the employee may refrain from giving the required notice or documentary proof in exchange for payment in lieu of taking PL. Well, the PL is different from the maternity leave. If the male employee does not inform the employer would not know that a baby is coming. So there is a required advance notice given to the employer for statutory PL entitlement, and there is also documentary proof required before PL pay is given. So that is different from maternity leave. So these requirements are necessary. The employer should allow PL to be taken and cannot replace it with payment in lieu. When notice is given, PL will be taken, and after PL is taken, when documentary proof is given, then PL pay will have to be paid. Failing to do that is a contravention of the law. The right is given to the employee to take PL, and whether PL is taken, the employee doesn't have to take PL. Say, for example, if the employee doesn't give notice to his employer would not know to give PL to the employee. So these requirements would not create loopholes. A member asked whether the employee has not left Hong Kong in the PL while the baby is born overseas, and whether the employee will be given the PL, or whether the employee, by doing so, has breached the law. And a member query whether an employee was in breach of the law if he worked for another employer during PL instead of taking care of the mother and the baby. And as to whether the father, as the employee as the father, has taken care of the baby, there is no such requirement, so we cannot include it in the legislation. And as to whether the employee can take up employment during the PL, under the EO Employment Ordinance, there is no restriction on an employee on taking up concurrent employment or restrain the personal or personal activities. So if the employer thinks that the employee cannot take up concurrent employment during any statutory holidays or leaves or PL, the employer can agree with the employee for the latter to not take up concurrent employment. In relation to prohibition against termination of employment, a member asked whether the employee taking PL should be afforded employment protection similar to that under maternity leave. I would like to explain that employment protection in relation to maternity leave starts from the confirmation of pregnancy as evidenced by medical certificate to the date on which she is due to return to work after the maternity leave. Well, except for summary dismissal due to employee's serious misconduct. No matter what happens, the employer cannot fire a pregnant employee. There is such employment protection of a pregnant employee because she may be hindered by her physical condition from performing certain work, and she needs to take leave for medical examination. So it's necessary to afford employment protection on the pregnant employee. And it also takes time for the pregnant employee to recover from childbirth. If there is no such protection and if she is sacked, it will be difficult for her to find employment until she is fully recovered. However, in comparison to a male employee, his physical condition will not differ much, will not change. So we think that there is no need to afford an employment protection that may last for 10 months just for a 3-day PL. And it is disproportional given the duration of the PL is just 3 days. And in relation to inclusion of PL in the notice period for termination of contract, if PL is treated as part of the notice period, it will be disadvantageous to the employee. Because in effect, after taking the PL, the notice period will be shortened by 3 days. That is the view of a member. But we think that denying the inclusion of PL in the notice does not always work to the advantage of the employee. Because, say for example, when it comes to resignation, the PL cannot be taken, and sometimes the notice period may be as long as 1 month. And if the PL cannot be taken during the notice period, then the male employee will not be able to take care of his baby during the paternity leave. In relation to notification requirement, a member said that in general terms, you can't say when the baby will arrive. So if notification is to be given to an employer, it may not be practical for the employee. However, some members express concerns that if only a short notice is given, the employer may not be able to make arrangements in relation to deployment. We want to strike a fine balance between the interests of employees and employers. We require advance notice, no less than 2 days before leave is taken. That's all. Thank you. We have Mr. Sin Chung Kai Kok Wai Keung who would like to ask questions. Any other members? Mr. Tan Kap Yu. 4 minutes each. Mr. Sin. This might have been answered before. I might have missed it in previous papers. If the employer is willing to give extra wage, say for example 200 days for the PL entitlement, he will be given $200. What if the employer offers an additional $200 for the employee not to take the PL? As we've said that PL pay and PL are two different things. Even after a sum has been given to the employee, the employee still has the right to take PL. As long as an advance notice is given to the employer will have to allow the employee to take PL. Otherwise, he would have breached the employment ordinance. Yes. But what if an incentive is given to the employee? Say, for example, if you don't take PL, then I will give you additional pay as compensation. And say the employee has agreed to receiving additional pay to not take PL. Is that okay? Well, after taking whatever sum offered by the employer, the employee can still ask to take PL. The employer cannot refuse to grant him PL, otherwise he would have breached the law. That means the employee can't have the cake and eat it. Otherwise, the employer would have breached the law. Yes, that is the case. Next, Mr. Kok Wai Keung. I think Mr. Sin has asked a question for employers. From the perspective of an employee, in relation to the 3-day PL, and whether it should be set off against the notice period. I think the Labour Department is quite stubborn. Last time I made it very clear that if it is payment in lieu of notice, if the inclusion is allowed, then they can use the pay of the PL to offset the payment in lieu. How are you going to deal with that? Because once it's offset, then PL will not be taken. What do you say? I understand that under certain circumstances, the inclusion of PL in the notice may be to the advantage of employees. However, in some other circumstance, it works against it. So can you give us some examples? When is it advantageous to the employee? As Mr. Kwok said, if it's a termination of contract, if a PL is not included in the notice, it may work for the employee. It depends on the actual situation. Sometimes it works for the employee, sometimes not.
Let's say an employee wants to leave the employment, and if the PL is to be inclusion of the PL in the notice period, then it would work towards the employee's advantage in some instances, because if the employee wants to leave his job early as opposed to wanting to leave his job later. So where the employee wants to leave employment, he will not, and where he cannot have the PL within the notice period, then he cannot do so. Take the PL in the notice period. Same analysis in the employer dismissal situation, where the inclusion of PL in the notice period is not admissible, then the employee will not be able to take PL within the notice period. I'm looking at paragraph 12. It says, for reasons stated in paragraph 10 and 11 above, the government considers that it would not be appropriate to extend the employment protection in relation to pregnancy and confinement to employees taking or intending to take paid leave. Now, the 2 or 3 days of paid paternal leave, some people say that it is perhaps too short, but perhaps under circumstances it is more appropriate to have 7 days or 14 days. I do not know under such circumstances why it is not the PL is not included into employment benefits. I think where the employee is already under a certain situation, then there may be family pressure. I think we should be aware of the situation of the employee and also respect the employee and the family. And given that the employee is under a family situation, that is, the wife is pregnant, there should be respect to his rights and sympathy to the situation. Well, indeed, at the time, where appropriate, we did say that the maternity leave and the PL should be as such. But after discussions and after referring to the EO, and we have come to the conclusion that the PL and ML should be different, and therefore the benefits should also be different. And further, we have also discussed whether PL should come under the employment benefits. But really, it is not only about the length of the PL. 10 weeks for ML, 3 days for PL, they are definitely not the same. But the reason why we afford more protection to the woman, it is because there are biological situations with the mother and not with the father. However many days we add to the PL, it would not be a situation that there will be biological changes to the man just because the wife is pregnant. And therefore, the PL would not be in the same situation as the situation of pregnant woman. We've come to that conclusion. And also, as a family-friendly measure, of course, we would want to provide more protection and benefits to the family concerned. But for the father, or the husband, it is not, he does not only care for the family, the wife and the baby just at the time of birth, but it is an ongoing responsibility and ongoing care. And therefore, in this analysis, we actually cannot extend the PL indefinitely just because the man has to care for the family on an ongoing basis. And we believe that where there are discriminations because of the man's employee's situation, the Equal Opportunities Commission can be resorted to. Mr. Chairman, our party is always in support of having the PL, but given the proposal now, I think it is overly mean, too stingy on the part of the administration. The PL only 3 days is way too short. Our party, the Democratic Party, has done some telephone survey, and the results we got is that PL is being 3 days is too short. The popular suggestion is 7 days. I will be proposing this change later. And another point where it is very stringent is where the pay is only 4/5 of the normal. I understand that this is in matching with the ML, with maternity leave, but let us look forward, not backwards. 80% for the pregnant woman is actually too low, and you are referring to something that is already outdated. Actually, we should afford 100% even for the ML. Now, you are coming up with a new bill, copying something that is outdated and something that we have wanted to change for the longest time, and that is not right. And also, when looking at the wording here, I'm not very sure about some of the terms. For example, 3 months' notice should be given for the PL dates. And then you go on to say that at least 2 days of notice, and then it goes on to say 5 days. Now, what are you referring to? What are you afraid of? You're afraid that the employer will not remember when the PL is, and therefore the employee concerned will have to remind the employer 2 days in advance. But on the other hand, we know that things are not so mechanical if it is a natural birth, and there may be premature births too. And one cannot very well foretell when the birth will arrive. And the father and the mother of the newborn, given that it's not a cesarean section, will not be able to tell when exactly the birth date would be, and therefore the PL would be. Well, a couple of questions there. One is on the notice period. First of all, the 3 months notice before the date of birth, basically the employee is to notify the employer only that he is to take PL without mentioning a specific date. All he has to say is that his partner or wife is about to give birth, and I will be, in the recent future, take PL. And it is understandable that 3 months in advance one cannot very well know the exact date of the birth. And where the person already knows the date of birth, 2 days in advance he will notice the employer of the date he's taking PL. And we want to strike a balance between the interest of the employer and the employee. We understand that the employee wants to take leave on a particular date, but there are members in the previous meeting who already mentioned that the employee cannot just walk off when he wants to from the office, because it may cause problems for the employer. So we do understand that the relationship between the employer and the employee, and in particular giving birth, having a newborn, is something that's very happy, and most employers actually do not mind having been given just 2 days of advance notice before the day of PL. And all along in Hong Kong, the employment relationship had been harmonious, and there are giving and taking on the part of the employer and employee, and it had been working smoothly. Mr. Chairman, that's right. One other question remains unanswered, the 7-day question. I know you've answered that question many times, and since we have colleagues asking the same question, would you please again? Yes, the 3 days in the proposal, well, in Hong Kong, there is no PL yet, so we do not have a reference pointer as yet. So we will only refer to the 2010, the 1,580 Managers Association, their opinions. And the PL that they offer without legislation is 3 days. And if you're talking, that's over 40%. If it's 1 to 3 days, that's over 80% or 83%. And in their discussions, there had been different proposals, and discussions have been made on those proposals. And finally, there was a settlement on 3 days, and therefore the 3 days is proposed here. Now, I understand, as pointed out just now, that the PL, we would want to make it commensurate with the ML. And there are other benefits, employment benefits for sick leave, for example, ordinary sick leave as well as leave for injuries, all fetch 80% of full pay. And the ILO enshrinement as also as such. At present, with the labor holidays and New Year holidays, etc., those are full payment leave. As for the ILO, it specifies no less than 2/3 of full pay. And here we are providing 4/5 of full pay. And this 4/5 was also decided upon as a consensus during discussions by the Labour Advisory Board. I have a few questions. First of all, on the number of days, we have made our stance very clear. We believe that it should be 7 days instead of 3. And if we are to amend this bill, I do not know what all members think, and the Labour Department, what they think. I think it is quite unreasonable that the Labour Department, well, always tells us that any amendments, proposals we make will have to go through the Labour Advisory Board. And, well, they'll be very busy. This is not, the board is not a consultative body for the LegCo, but rather for the government. I would really like to know what the procedure should be for any amendment proposal. Well, Sin Chung Kai said that there will not be a second reading. We shall see.
In relation to employment protection, I do think that the notice period should not include PL. And you said that, say, for example, if it's 1 month notice, then, well, you would have been fired before you take the PL. But there are 2 parts to employment protection. One, if you fire me before I take PL, you will have to pay for the PL. The second leg, taking the example of maternity leave, it will be illegal dismissal or unlawful dismissal. So at least you will have to give them compensation of 3 days. If the Labour Department thinks it is not unlawful dismissal, well, I don't think employers would fire someone just for the 3-day PL. Well, what if a compensation for the 3 days is given? What do you say? We now propose 3 days in the PL. If members propose more than 3 days, we will have to have a discussion with the LAB, the Labour Advisory Board, just like any other policies, established practice. When it comes to employment protection, we will only put forward a proposal after consensus is reached in the LAB. Well, what if a member proposes a CSA? If it's only a technical amendment, well, what if Ms. Helena Wong or Mr. Liu Cheuk-yen proposes a CSA for 7 days? well, then we will have to revert to the LAB. That means you will not be able to introduce the bill. The bill has already been introduced. We will only resume second reading after we have consulted LAB. How long are we talking about? It depends. I can't say how long the LAB will need. The second part is employment protection. I've explained why is not to be included, and as to whether a 3-day pay can be made to the employee. In general termination, say you have not worked long enough to earn statutory leave or annual leave, then you will not be paid for that. And in the case of PL, say for the first 3 days of the Chinese New Year, if you are terminated before the Chinese New Year, you will not be paid for the 3 days. That is the same. Maybe you wait for the next round. Next, Mr. Chung Kok Pen. It says here, payment in lieu of PL. Under the bill is not allowed, even if an agreement is reached between the employer and the employee. But can there be some flexibility? Some employees, they may take the PL and then take up part-time work somewhere else. They just want to maybe make a bit more to pay for the additional expenses as a result of the newborn baby. And for some employers, they will have to recruit a replacement during the period of the PL. And for some employees, if the mother is giving birth outside Hong Kong, the employee may stay in Hong Kong during the PL. Then why don't you allow payment in lieu of statutory PL? When PL is taken, pay is only 4/5. I am an employer. I have to offer full pay to the replacement, and at the same time, I have to pay 4/5 of the wage to the employee. So the employee will receive 4/5 of pay anyway. So why don't you allow payment in lieu? If that is accepted by both employees and employers. All leaves under the employment ordinance cannot be replaced with payment in lieu. This is a result of after having taken into consideration employees and employers. So we think that payment in lieu should not be allowed. I'm not speaking for the administration. My understanding, when it comes to the bargaining power of employers and employees, that is not equal. If you allow employers and employees to settle this with payment in lieu, which is higher than the normal pay, then you don't know whether the employee willingly accept the offer of the employer. And that itself is a consideration considered by international labor organizations. Mr. Zhong, I understand. But under the law, it is stipulated that it will have to be on his own. Well, the employee will have to be willing to do that. Otherwise, he will take the PL. So they should be allowed to work it out themselves. Anything to add? No. Next, Mr. Ray Chan. a technical point. The procedure of CSAs, committee stage amendments. A member said that he might move CSAs. Well, if the 3-day PL is to be changed, the assistant commissioner said that they will have to revert to the LAB, and he doesn't know how long it would take. But what if it's reduced from 3 days to 1 day? You still have to take back the bill and revert to the LAB? And someone told me that the long title, if it's written in the long title, then can we still move amendments to the long title? What in the long title? The length of the leave, say 3 days, 4/5. I defer to the legal advisor. In relation to the amendment to the long title, the purpose of the long title is to outline the content of the bill and elaborate on the legislative intent. And as to whether amendments can be made to the content of the long title, here is stipulated it will be 3 days and 4/5 of the daily wages. Whether an amendment can be made, it depends on Rule 57(4) of the Rules of Procedures. That is, whether the amendment is related to the theme. And when the President consider whether it is related to the scope, they will consider the long title, and on top of that, he may consider other materials, say for example the electrical brief and other papers available. So it will not be limited by the long title, because in the end it's for the President to make a ruling. Mr. Hui, please reply to Mr. Chan's question. As I said, it depends on the amendment. If it's very different from the view of the LAB, we will have to have another round of discussion. But if the difference is very small, then we may not have to go back to the LAB. Say for example, if it is reduced, well, we will have to consider whether it is necessary to go back to the LAB, and we think that the LAB will not agree to that, because employers and employees will not agree to that. So if there are amendments, the next step is for you to go back to the LAB, so the process will be suspended. We will revert to the LAB to seek their views before we resume second reading. So there may be a long pause. I'll reply on behalf of Mr. Hui, and I stand to be corrected. Second round, Mr. Sin. According to the procedure, whether it's Helena Wong or Mr. Lee, it's only a notice. The reasonable procedure is that we can move CSA. But we may not have to give notice here. We may give notice in the House Committee. Is it the case that if there are any amendments, you will not resume second reading? You will only revert to us after you have finished discussing with the LAB? Yes, we will have to discuss with the LAB. If the LAB does not agree with any change, What are you going to do? Are you going to resume second reading? Can you answer, Mr. Hui? I can't say at this stage, because I don't know what the future discussion of the LAB will be. We will have a discussion with the LAB. Depending on the result, we will make a decision. I think it's difficult for the LAB to make a decision because the labor side may agree, whereas the employer side may not. The chance of reaching a consensus may be small. Now, you can come back and tell us that there is no consensus. Only three things can happen. They support, they object, or they object to 7 days, they agree with 7 days, or there is no consensus. I can't think of a fourth scenario. You say you can't tell what the result will be, and I can tell you that there can only be one of three. Support of the 7 days, object to the 7 days, or there is no consensus. What will you do? You won't resume second reading, right? So how are you going to deal with it? I don't want to speculate as to what the decision of the LAB will be. Yes, I know that. But what will the administration do? Don't tell me about the LAB anymore. I'm asking about the administration. There can only be three possibilities. How is the administration going to deal with it? And I think we will consider how to deal with it after we know the result of the discussion of the LAB. Well, you may not know, but there can only be three possibilities. Can you maybe tell me how the administration is going to do under the three scenarios? We're not talking about 100. I think Mr. Hui doesn't have the mandate to answer that. I would like to hear from the Assistant Commissioner, not from you, Chairman. Okay. It depends on the result of the LAB discussion, and we will then consider what to do. We can't say at this stage what we will do when there is a consensus or when there is no consensus, because there may be a different proposal. So I can't say at this stage what will happen, because it really depends on the result of the discussion of the LAB. To be fair, the resumption of second or third reading will be suspended for a very long time. Yes, if we revert to the LAB, it will take a very long time. From your experience, by long, you mean years, months, days? So, okay, how long does it take you to arrive at the 3-day proposal? Back in 2012, April or May? Anyway, the second quarter of 2012, we started the discussion. So when was a consensus reached? November 2012. And of course, it depends on the nature of the discussion and the matter under discussion. Say, for statutory leave, when the compensatory leave is to be made, it only takes a very short time to reach consensus, whereas for others, say, statutory minimum wage is taken years. So it depends on the topic. Mr. Tang Ka-piu. Thank you. I was going to say, before we finish with the first round, that employment protection covers not just maternity leave, but also sick leave and injuries. So you should collect our views before saying that you will not consider. I was going to say that I wanted to move a CSA when it comes to employment protection. When it comes to days, of course, we want 5 days, 7 days, or even 14 days, but we respect the LAB. And by the sound of it, you're threatening us not to do anything by saying that you have to revert to the LAB. I think there is a sense of threat in that. You said, assuming there is no consensus within the LAB, I don't know how you're going to do it. You're going to give them a form to put it to a vote on members' CSA, or you will keep creating more issues for discussion?
You
didn't make that clear. Now, if there is a lack of consensus, will you continue with the second reading, or would you actually not go ahead with it, which is like withdrawing? I'm very worried. Would you be withdrawing this bill? Thank you, Mr. Chairman. Well, what proposals will be taken to the LAB? It depends on what you, as members of this panel, will make as proposed amendments. And whatever proposals you make, we will definitely reflect to the LAB. And I can imagine, well, I have to say, at this stage, I do not foresee giving each of the members of the LAB a form and have them tick against their choice, because that had never been the mode of operation. It has always been discussions, and discussions producing consensus. And that is one of the reasons why we have been very harmonious in terms of employment relationship and also in labor benefits deliberation. The mechanism had always been discussions, full discussions at the LAB. Well, you have not answered my question. My question was, if at the LAB we're not able to convince, or you're not able to convince the employer side of the members, will you be continuing with second reading of this bill? Mr. Chairman, as I have mentioned just now, I do not want to take that hypothetical case, because different members may have a number of proposed amendments, some technical, some non-technical in nature. Now, having heard you, I may not accept your response, or I may find it repugnant. We may start CSA. Now, if we start CSA, there will be no turning back, and you may have to put your bill into the drawer for a long time. Would you please consider the question then? Well, I do not rule out any possibilities. Really, I cannot foresee the results of the deliberation of the LAB. Well, but hold on, there are 12 members there. Where there is no consensus, will you resume second reading? Well, we will have to see the discussions of the LAB, what they can agree on or reach consensus on, what they cannot, the results of the discussions of the LAB before. Well, hold on, Mr. Chairman, has this happened before, where a bill had been put into the drawer before resumption of second reading, that is, withdrawing a bill? Mr. Chairman, I do not know. I cannot remember one way or the other, really. Mr. Chairman, I think this will have grave consequences. The administration representatives sitting in this room are unable to commit one way or the other. They dare not say what the possibility, the outcome would be. And it says here, given that the number of days of the PL and whether it is 100% or fully paid, we can raise our amendments. Yes, legal advisor? Well, whether members can raise amendments, it depends on the chairman of the LegCo. It depends on whether the proposed amendments are pertinent to the bill itself, not just the long title, but other content. That is to say, apart from this long title, it does not decide whether members can raise or cannot raise amendments. So the point is whether we are legislating or whether the LAB is legislating, because we have been threatened to think by the administration that they will withdraw the bill and not resume second reading. Now, this is shocking. The LegCo, at this panel in particular, is a seat of legislating. So if any amendments is the prerogative of this particular panel, and the consensus here or the decision here will be forwarded to the House Committee, but you're saying that no, if we raise any proposals for change, we'll withdraw it or suspend second reading. Now, for dates of the PL, number of days of the PL, and whether it is full pay or not for these issues, if we are to raise any amendments and you're saying that you withdraw the bill, if we do so, then you are undermining the power of the LegCo in its legislative responsibilities. Now, often people say that you are hollowing out the LegCo, and are you trying exactly to do that? I mean, if the government is to close the door and have the behind closed doors have the employers and employees fight it out among themselves, that it will come to naught. Now, basically, what we need to decide on is whether the father, where he is needed most by the wife and by the family, be given a PL. I mean, if we agree to that, we should ask what the expectations is. That a paltry 2 to 3 days is insufficient. And a member just now, a colleague of ours, just asked whether payment in lieu of a PL is acceptable. Well, from the Democratic Party's point of view, it is not. In the modern day context, it is not acceptable. Well, Mr. Chairman, we have to look at the interest of both the employers and the employees. It is not to be one-sided. We look at both sides and their respective interests before we come up with this bill. And as I have mentioned, this has always been a success factor underpinning our employment relationship. Now, and another point, for this bill, yes, we will follow the procedures of the LegCo for resumption of second reading and when to resume second reading. We will definitely follow the procedures of the LegCo. We would not contravene any of that. Well, you cannot, Mr. Hui. You just simply cannot, and we will not allow it. Rest assured. Mr. Lee Cheuk-yan. Well, that is all rubbish about not contravening the procedures of the LegCo. Let me put a question to Mr. Hui. Before they come to the LegCo, did the LAB reach a consensus of PL of 3 days? Well, if that is a consensus, well, just tell us that that is a consensus. We all know that the consensus is 3 days. You do not have to go back to the LAB. We all know that. The fact that you're going back to the LAB means that you are not very clear, not very sure whether they support 3 days or whatever days. If their consensus is already 3 days, the fact that we want to change or amend the 3 days, what business is theirs? Or if I can be courteous and polite and say, yes, it is their business as well, LAB, then they should consider again whether our proposal, the LegCo's proposal, is reasonable. Well, by so doing, Mr. Hui, going back to the LAB, you know full well that their consensus is 3 days, and they will not be acceptant of our suggestion. So what you're trying to do is to threaten the LegCo so that we withdraw our amendment or hold our amendment. Well, I do not know how many years of this have I been put through, and it's been years or over 10 years of pain on our part, and they've done this time and again. But I think this must come to a stop. There is no reason for bringing this back to the LAB. Their consensus is 3 days. Why do we have to bring this back to them? They already had reached their consensus, and we propose, let's say, 7 days. Why do you have to go back to them? This is completely unnecessary, and it is not a sincere act on your part. I mean, if it were a sincere consultation of the LAB, you can very well just call the members of the LAB right now and ask them whether 7 days is acceptable. But you want us to come up with the amendment of, say, for 7 days, and then you go back to the LAB. That's what you're saying, but that is a threat hurled at us, and we will not kowtow to that. Mr. Hui, I want you to go back and come back with a written reply whether you are threatening us with this and to undermine the right of LegCo members in making amendments. And this is not the case for other panels. It's never been that whether it be the transport advisory or some other advisory boards, that it's never been done. It's always the Labour Department who's been playing these tricks on us for the longest years. And this is all that I can take, and once and for all, I want you to come back and tell me with a written reply whether this is a threat from you to the LegCo. Yes, let me try to answer that question, Mr. Chairman. Well, the Labour ordinance is not being amended for the first time, nor the EO. And for the longest time, we have been following the same procedures, and that is with a consensus reached at LAB, will come to the LegCo, and where there are different opinions raised by the LegCo, we will go back to LAB. And we have had a number of ordinances which had been raising the treatment and benefits of employees, which have been consummated and done exactly in that manner, and that is for any changes that you propose, we will have to go back to the LAB. We're following the same procedures as before.
Indeed, there are a lot of employees who would like to have a longer period in the PL, and at the same time there are a lot of employees who would like to see this implemented as soon as possible. They wonder when it will be endorsed in time for the birth of their babies. I want to get some answers from the Assistant Commissioner. I do think there needs to be some answers to the possibilities outlined by Mr. Xin. You can't say that, well, if you move amendments, you will have to revert to the LAB. You should have a second fiddle to your bow before, and you will have to tell us that before we decide whether we will move any amendments. We need to know what is in store for us before we make a decision. I heard from the Assistant Commissioner that PL is not essential. You talk about offsetting it with the notice period. We asked you for compensation of these PLs, and you also say that there should not be any compensation. Well, the old employer does not pay for the PL, but the new employee but the new employer doesn't have to grant PL. So in the end, the employee doesn't get any paternity leave. Assistant Commissioner, I will give you a written reply as to how the paternity leave is to be dealt with or without CSAs. And if an employee changes employment, well, for PL, there is no requirement of 40 weeks. There needs only a continuous contract of 4 weeks before the employee can enjoy paternity leave. So when all the requirements are met, when the employee has worked for 4 continuous weeks, then the employee can enjoy the PL, not 40 weeks. We're talking about paid PL, and you now tell me that the unpaid ones is still paternity leave. We're not happy with the pay being set at 4/5 anyway. We are talking about paid PL. We told you that there are certain scenarios in which employees will have to take unpaid PL. Mr. Allen Leung, there are certain issues that cannot be circumvented. The LegCo is not a rubber stamp. We don't have to endorse whatever proposal you make. I'm sure the Assistant Commissioner knows full well. The LAB is only an advisory body. The administration consults them, and in the end, it's the administration that makes a decision. And the administration will have a stance and a bottom line. I don't think you should use the LAB as an excuse at this stage. Of course, I would like to know whether I'm wasting my time here. Say 15I and J. It says, it talks about documentary proof. Can we propose any changes? Well, I'm talking about the stance of the administration, not that of the LAB. Are we allowed to propose any changes? Because this is not just about 3 days and 4/5 of pay. There are other details as well. Is it the case that we cannot touch them at all? You are the administration. You can tell us outright what your stance is. You can tell us what your bottom lines are. Bottom lines that cannot be changed. And once there are proposals to change it, then we will withdraw the whole bill. Tell us that. Don't waste our time. And tell us that it simply cannot be changed after we have scrutinized the entire bill. Tell us what your bottom line is. We may not agree with you, but tell us what your bottom line is. Don't be so vague. There are many provisions under this bill. For technical ones, if there is little difference between the proposal and the decision of the LAB, then we can go ahead. But if the proposed amendment is related to the consensus of the LAB, say for example the number of days, we know that the LAB has discussed the length of the PL. Well, I cannot say that a consensus was made in November 2012 and whether a different consensus will or can be reached in the future. That the length of the PL is a very important provision. So is the level of pay, pitched at 4/5. So these issues will have to be discussed by the LAB as well. Under the ROP, some members may give advance notice to move amendments. You follow the ROP, and the President will make a decision as to whether to allow the amendment. But is it the case that if it touches the long title, then the administration will definitely withdraw the bill? No, it's not just about the long bill, the long title. The long title is not the only part that we need to consult the LAB. But of course, the long title contains the most important elements under the bill. Give me a list then. What are the issues that you cannot budge? Give us a list. But don't waste our time, Mr. Hui. Maybe you give us a list, or you ask the Secretary, Mr. Matthew Cheung, to come and talk to us. Put everything in writing so that we can proceed from there. Mr. Sitho, Miss Sitho, if nothing can be touched, if you won't budge an inch, you should have sent us a letter objecting to the establishment of this Bills Committee. Well, nowadays administration loves to write letters to us voicing their objections, say for example misconduct. What are the technical amendments you mentioned? Don't waste our time. Give us a paper. Give us a list. What are the things that you will accept amendments, and what are the issues that you will not accept any amendment? Don't worry, even if a bill is endorsed, the chief executive can refuse to not sign for it to actually come into effect. Say, for example, there is one before 97. Chris Patten was too busy to do that, and in the end, Mr. Lee Cheuk-yen's bill fell through. You can do everything. Don't be so don't be a hypocrite. Tell us, give us a list as to where you can budge and what areas you can't. Well, in the past, there was a proposal that you will have to give a notice of at least 48 hours before you can take maternity leave. And I don't know whether the person proposing that has ever come across birth. You think that when it comes to natural birth, it's punctual like an alarm clock? In the law, you specify that it has to be, the notice has to be given 48 hours before. You said it's technical. So if you have 5 employees or less, it's not technical. But if you have dozens of people, then these are technical amendments and can be accepted. Don't waste our time. I do look forward to the list from the administration telling us what amendments are not acceptable to you. This is worse than the Country Park Ordinance. The other time, it was said that we're not allowed to move amendments. At least they gave us some information on a legal basis. But now, tell me, Under which employment ordinance or what labor legislation are we not allowed to move an amendment? Mr. Hui, can you give us a list? It's difficult to just say off the top of my head what amendments can be made and what not. No, it's not off the top of your head. Just tell us from the Blue Bill which provisions can be amended and which not. Just tell us. Well, you either take against those that you will consider budging, or taking against those that you will definitely not budge. So it's only from CA to C120. So about 20 pages. It would be easy to go through it. Mr. Hui, I look forward to your written response. Third round. 3 minutes each. Mr. Sin Chung Kai. The LAB is an advisory body. Whether you will revert to the LAB, I don't have a strong view. I'm different from Lee Cheuk-yan. I think the most important thing is what you come back with after consulting the LAB. You don't have to be a member of the Bills Committee to move CSA. As long as you give sufficient notice. Does it mean that every time you receive a notice of amendment, you will go to the LAB? You have to consider this. I gave you 3 scenarios. Consider them and give me an answer. So you just tell me, okay, 14 days we'll definitely withdraw it, 7 days you will not withdraw it, 6 days you will not withdraw it. I gave you only 3 scenarios. And now I ask for all the different scenarios and what you're going to do, whether you withdraw the bill, you will not resume second reading, or the CE simply refuses to sign to give effect to it. We will give a written response. We will not be able to give an exhaustive list. We will give a general answer. Ms. Helena Wong. The object of the bill. Up to 3 days paternity leave. What does it mean? What if it's 1, 2, or 3 days? Would that do? Well, paternity leave of up to 3 days. Because we have now set it at the maximum level of 3 days. That's why it's worded this way. The law says that it can be as long as 3 days. Then why did you not simply say 3 days? Now you say up to 3 days. That means you can take 1 or 2 days only. Mr. Hui, I would defer to Mr. Lam.
This is actually a ceiling. The employee can make a decision whether he wants to take the full 3 days or not. But in any case, it will not exceed the 3 days, the PL. Now, what if the employer only gives PL for 1 day? Is that against the law? But it says here maximum 3 days. So 1 day does not violate maximum 3 days, does it? Yes, a long title. Yes, the employee has a right to enjoy a maximum 3 days. So the right lies with the employee. Mr. Chairman, I would like to know how we can avoid in enforcement any difficulties in terms of understanding this 3 days. Now, is this part of the bill or not? Paternity leave of up to 3 days. 15B2 there talks about the actual days. The long title just basically describes the content of the bill. Well, it says here, leave of up to 3 days. How is it different from leave of 3 days for the long title? Well, the drafting of the long title is a decision on the part of the administration, because there is no rule as to how the long title will reflect the content of the bill. In fact, we should always look at the content of the bill for the import of the legislation rather than to look at the long title. In fact, after the passage of the legislation or the bill, the long title has very little significance. A long title is really to help members, electoral members, understand the bill. I understand. Just a point of supplement. If you want to amend the bill, you should amend 15B2 rather than the long title. You should amend the section 15B2, and the long title will reflect that change. So the long title is not the main content for changing, or main subject for changing. Mr. Lee Chuk-yen, Mr. Chairman, I'm looking at up to 3 days, quote unquote. Now, Mr. Chung, my colleague just now, said that there cannot be payment in lieu of leave, but it says, well, the way it is written here actually suggests that there can be payment in lieu of leave. For instance, the employee can, instead of taking leave, get 6 days pay from the employer instead. That is to say, 6 days pay in return for 0 day of leave. So the employer, in exchange, provides 6 days of pay. And in that case, it will contravene the spirit of payment in lieu of leave. Does Mr. Hui confirm that? And there is another point I would like to make, and that is I withdraw from this panel. And if I withdraw, would you not have to go to LAB then? I mean, as the panel discusses raising 3 days to 7 days or 14 days, I mean, if there is somebody at the reading, at the second or third reading, proposes 7 days or 14 days, does it mean that immediately you will go to the LAB again? Because whatever amendment from whomever, whether from this panel or not, you'll go back to the LAB. So you are in fact tricking and frustrating 70 electoral members. Long title. Now, I'm not talking about the long title. I'm talking about the legislation, the bill itself. The long title may be misleading. If you talk about the long title, I'm talking about 15B2. Well, it says the employee will have the right to take leave for up to 3 days. And in our written submission or response to members, we have also reiterated that the PL is a right of the employee, but we will not force the employee to take PL. There may be a number of reasons why the employee does not want to take leave. Well, in that case, why do you not allow payment in lieu of leave? Well, the law does not allow for payment in lieu of leave. But that's exactly so. I mean, you understand, let us say that we're not stupid, you and myself, and in fact this is a de facto payment in lieu of leave. We all understand that. Mr. Chairman, I'm not talking about the PL specifically, but for any leave, maternity leave, for instance. For example, for whatever reason the employee does not want to take leave, whether the employer gives extra pay or not, and the employee does not want to take leave, that's for the employee to decide, because the employee has a right to take leave, not that we want to force the employee to take leave. So you're saying if the employee says, I do not want to take leave, or I want to take only 1 day of leave, what you're saying is that in any case the employer will have a criminal offense, have committed a criminal offense if the employee chooses only to take 1 day of leave. Well, if the employee wants to take leave, but the employer does not allow the employee to take leave, then there is a criminal offense. But the employer does not have the responsibility to force the employee to take leave, whether it be 3 days or whatever. Let's say, for instance, the employee does not know. Well, hold on. Mr. Chairman, yes, if the employee does not give notice, then it would not trigger off the PL. But by saying this, the way you put this, there can be payment in lieu of leave, in fact, isn't it, by saying up to 3 days. Yes, I want you to think about it, where the employee takes only 2 days or 1 day of leave, and the employer finds that acceptable. Is the employer then liable? I want to be clear on this point. Can you please give us a written response on that point? Yes. And Mr. Chairman, also another point. The ML is not up to 10 weeks, right? The wording is not as such, right? Up to 10 weeks, isn't it? Please confirm or disconfirm that. Right. Anything else? There is another document. I do not know. Well, Mr. Chairman, there was another question unanswered, and that is, if I withdraw from the panel, you have to write to me. No, I'm not just saying that. Of course, if I withdraw, I will write to you. But for other LegCo members who are not on this panel, and if we notify the LegCo that there is a second reading, and there would be a period in which LegCo members can make amendment proposals. Is Mr. Hui saying that he will withdraw right away and seize the second reading, if that is the case? Says he has the right. I will have the right. So, Mr. Chairman, he's making a threat. He is implying that he will withdraw. I want a written response from you. Will you or will you not withdraw given a proposed amendment? You're saying that dare you, any one of you 70 LegCo members, dare you make an amendment. If you dare to make an amendment, we will withdraw. Is that what you're saying? Well, not a verbal response. Would you please give a written response to that? Sid Ho, 3 minutes. No, Mr. Chairman, if there are certain employers who are within our midst who are actually against PL, at all, any PL at all, whatever the number of days, then all they have to do is to make a proposal for amendment, and you'll have to withdraw. Has the Labour Department thought of that? Well, Mr. Chairman, I think as I said, we are following the normal procedures for labor ordinances or labor-related ordinances, and I'm sure that we are all rational, including the LAB, and we have followed this time-honored mechanism, and there have been a number of ordinances and amendments passed that are beneficial to employees. Mr. Chairman, I think the government has a number of votes, and through their secured votes, they will be able to veto Labour representing LegCo members. They can vote them down and vote their proposals down. And it's never been the case, as we are seeing here, that they will withdraw the bill altogether. I mean, it's never come to this. Now, then I want to understand what this time-honored mechanism is, or the existing mechanism is. What do you mean by that, Mr. Hui? Well, Mr. Chair, for any bill that comes to the LegCo for changing or improving the benefits of employees, we always go to the LAB first, and they reach a consensus. As Ms. Sit Ho had mentioned, after consulting the LAB, where the LAB finds acceptable, the government, that is the administration, will come up with certain amendments where the LAB had discussed and decided that on certain points and certain changes, then the administration will bring these to the LegCo, and that had been the mechanism. But I'm not saying for this time what we'll do. I think for this round, the administration is being very repulsive. Please don't put the onus on LAB. Please assume responsibility, since you are so clear and adamant that the moment we raise amendments, you will take this back and withdraw this. Let us not, or please do not hide behind the LAB, but rather, if you do not have sufficient votes to vote down whatever amendments we provide or we propose, then you would withdraw. Why are you being so firm this time, saying that you will withdraw the bill for whatever amendments we propose? Well, Mr. Chairman, I just want to say we are still honoring the mechanism. And at no point did I say that we are going to withdraw this bill. All I said was that we will, before second reading, if there should be amendments, go back to the LAB for discussions. All right. For this document, I think we are fine for the moment. We are waiting for Mr. Hui's written response. Now, there is another paper, and that is a letter dated 10th of May from the Law Society. (154013/14) You do not have a written response to this letter, but would you give us verbally your response to this letter for our knowledge, please? Yes, I can do a preliminary response, Mr. Chairman. Well, basically, it says that there are 5, or rather 6, opinions that they want to put forward. I will go through them one by one.
The Law Society is of the view that, that there is a different definition between the maternity leave and paternity leave. For maternity leave is more lengthy.
Provisions of Part 3 by a female employee because of her pregnancy or confinement. 而產假方面咧就寫得比較簡單啲嘅，就係 means
and paternity leave.
A。咁就住呢個有關草擬嗰個方面咧，我想請
So when it comes to drafting, I would like to defer to Mr. Lam from the DFJ. Thank you. The definition of paternity leave is similar to the wordings of, or the definition of annual leave. The drafting is straightforward and simple. We don't think the definition of PL should not be based on that of maternity leave. We think that the current definition is clear. The Law Society is of the view that the definition of father should be set out. And we think that at the time of drafting, we don't want the definition of a father to be set in stone, because it may be a biological parent or father or a legal father. The father-in-law. Before the baby is born, there is no father-in-law. But during the pregnancy, the father may want to take PL before the baby is born. If we say that it is the father-in-law, then the person will not be able to prove that he is the father-in-law. We don't want the definition to be so rigid. After the PL is taken, and if the father wants to take PL leave, then he will have to produce documentary proof that he is the father. In relation to the 3 months notice period before PL is taken, the calculation starts from the expected date of delivery and 3 months before that. The Law Society is of the view that it should be 3 months before the PL is intended to be taken. We want to use the expected date of delivery because it's easier, because we need a reference point. When pregnancy is confirmed, there will be a medical certificate stating the expected date of delivery. Putting it this way will give certainty as to when the employee will have to notify the employer. We understand that very often the father may not know when he will actually take the paternity leave. If we use taking the date of the actual PL as a reference point, maybe in the end the father will take PL earlier or later. We think that it will be clearer to use expected date of delivery as the reference point. It will be clearer. The 4th point, notification to the employer that PL is to be taken. It can be done verbally. But when the employer asks for a written notification, then the employee will have to furnish the written notification, and only at this stage. The Law Society thinks that written notification should be made mandatory. That is, when the employer is notified about the intention of taking PL, it has to be in written form. When we draft the bill, we know that in general there is a harmonious relationship between employers and employees. And very often you only make a verbal request or verbal notification when it comes to taking leave. That is the case for maternity leave. A verbal notification is required, and only a verbal one when it comes to maternity leave. And it's only when the employer makes a request that a written notification is to be given. We think this will be beneficial for both employer-employee relationship. In relation to 15H(3), calculation of the daily wage pay. And is slightly different from the wording under clause 14(3)(b). The Law Society asks why. I would like to defer to Mr. Lam. The Law Society proposes to compare 15H(3) with 14(3)(b), and they ask why it's slightly different. The difference lies in the fact that there are paragraphs A and B and the word is regarded is in clause 14. We want to avoid that in a new legislation. That's why at 15H we will change it to having regard to paragraphs A and B. It's a different way of expression, but it's a clearer one. The second difference is that in relation to the excluded period under 15H3A, we added this for easy reference instead of using the old approach under 14.3b, which is a more mouthful. The daily average wage or average daily wage, they are the same, right? Yes. The legal advisor asks questions, and legal advisor, would you like to add to it in relation to the definition? Thank you. No. If there is already a proper way of drafting, why do you not change the other definitions? The impression I have is that a lot of the provisions under the employment ordinance is littered with inadequacies. There is no consistency. Why don't you consider standardizing and improving the definitions? The EO was enacted in the 1960s, and as the chairman said, it has gone through a number of amendments. If we standardize the drafting, that will be a major amendment. So at this stage, we don't want to introduce major amendments. So we only adopt the better way of drafting in this exercise and not other provisions. Apart from 43B, has the legal advisor looked at other provisions where there is inconsistency in relation to the average daily wage? It has made appearance in many legislations and provisions. Well, if it is a daily wage, then it's calculated by on the basis of daily average wages. And if we are to introduce amendments to this, it will be a huge exercise involving many different pieces of legislation. So we can't, we won't consider it at this stage. Legal advisor. In relation to the average daily wages, it appears in many provisions, say in relation to annual leave, sick leave. If there are amendments in relation to PL and there is no consequential amendment to other provisions, and it may create difficulties in the interpretation of the various provisions. Ms. Chan Yun Han, you have 4 minutes. Thank you. I agree fully with the chairman. The EO has been in place for a very long time. Yes, it's true that is fraught with inadequacies. There needs to be amendments. But I agree with Mr. Hui that it's difficult to do it at this stage. Would the administration consider setting aside time to go through all that, say for example 4/5 Well, when an employee is on maternity leave, the employee cannot be sacked. Otherwise, it's against the law. And you also talk about standardization. Can you give me more information? When it comes to legislative amendments, there are many proposals. We are continuing with some. Say, for example, apart from the paternity leave, there is also the right to reinstate employment. For some, say, for example, 4/5 or full pay, have you set a date to deal with them? Then it's not about drafting. It's about employment benefits or improvement of employment or employee benefits. Now, it's not just an improvement, it's about standardizing. Well, it's not standardized to be 4/5. No, but there are some others that give full pay. There is a distinction made by the ILO. Say, for example, statutory leave, statutory holiday, annual leave. According to the ILO, it has to be full pay. There is a different group, say, for example, maternity leave, sick leave, or leave from injury. The ILO states that it should be 2/3. There is a distinction, and we have taken reference from that. I don't know about other countries, but I believe that for other labor organizations in other countries, they will share the same view. It's very important. That's why we have to ask the same questions. You told us that you will only focus these provisions in this exercise. That's why I asked you when you are going to conduct a review on the level of pay. I only have 4 minutes. We have to standardize this. Well, when you're on maternity leave, you cannot be fired. What about paternity leave? In relation to employment protection, that is when a pregnant employee cannot be fired from the time when pregnancy is confirmed to the end of the maternity leave. It's there to protect a female employee after taking into account the situation of a pregnant employee. And this situation does not appear when it is a male employee. If we give the same protection, it will be disproportional. I think this question has been answered 4 to 5 times. Next meeting. In the next meeting, what needs to be done is that the administration should give us a written response to the paper of the Law Society. And a number of members have asked for information about how you are going to proceed in face of CSAs moved by members. In relation to a number of issues, say for example the length of the PL and pay and protection. There is no consensus between this Bills Committee and the administration. Well, we're going to have the next meeting on the 9th of June, Monday, 2:30. After we have finished discussion of how CSAs are to be dealt with, we will go into clause by clause. Members may have questions on 3 major areas. Members may move CSAs after we finish with clause by clause. Maybe I'll adjourn the meeting, and I thank the administration for joining us.